For motion.
Mr. Lordship,
Yes.
Lordship, this matter is with regard to compassionate appointment. This instant contempt petition is arising out of a non-compliance of the respondent authority to the Honorable Court order dated 15/12/22 as per with the memorandum and addendum of the PNR Department, Government of Nagaland. For the perusal of the order, Lordship, may I take you to the Annex 1, page number 9. The third
Yes.
paragraph. Lordship, here the Honorable Court directed the respondent authority number 2, Engineer-in-Chief NPWD, to consider my case within 3 months, strictly in terms of Office Memorandum 1709-2015 and addendum dated 09-04-2019, issued by the Personal and Administrative Reforms Branch, Government of Nagaland. Lordship is being more than 9 months, and still the respondent authority has not considered yet.
Yes. Where's Jimomi? Bijimomi, where is Bijimomi?
But at this stage, I think notice has to go, Worship.
Huh?
Notice has to go to the.
No, this order was passed on consensus. Jimomi?
I mean,
Mr. Jimomi appeared and on consensus on the motion stage, this was passed. Why unnecessary? Who has to consider respondent number 2? Respondent number 2,
Yes, Lordship.
Engineer-in-Chief. Huh?
Lordship, even the governing letter was duly served to the respondent number 2 as well.
Yes.
The governing letter, along with the order, it was served to the department, and the receipt was also acknowledged.
Okay.
Annex 2, page number 11, Lordship.
Heard Mr. So and so, counsel for the petitioner. The decision application under section 11 and 12 of the Contempt of Courts Act 1971. Read with Article 2215 of the Constitution of India. Alleging willful and deliberate violation of the judgment and order dated 15/12/2022, passed by this court in WPC number 331 of 2022. Issue notice returnable 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the respondent numbers. Respondent number 1, 2, 3, 4 and 5. The rest of was within 3 days. List after 4 weeks.
4 weeks. Request.
Item number 26.
Yes.
Okay, please, my lord. My lord, where the petitioner is approaching this honorable court is that the chief judicial magistrate who was in charge of the Kifli, who was being promoted and transferred. So for more than a week, the proceeding has not been there in the Kifli. So the petitioner is approaching this honorable court.
Yes.
Yes. The chief judicial magistrate who is the in charge of the Kifli court.
Yes.
He is being promoted and then he was transferred to other place.
Yes.
So there's no permanent magistrate at the moment. So the petitioner is approaching this honorable court for bail, my lord.
Why? There's no magistrate
Yes,
in
lordship.
the district.
Yes, yes.
Which district?
Kifli, lordship.
Leonard Vipi?
Lordship.
Why no magistrate in the district?
Lordship, that I'm not aware, Lordship. That I'm not aware, Lordship.
You must be aware. You are public prosecutor.
But most probably there must be a magistrate, but however, he might be, he or she might be on leave. Lordship. Or else there is a magistrate, Lordship, in every district. Lordship.
Can this be allowed like this? No magistrate in the district? What is this?
Lordship, in every district there is a magistrate, Lordship.
He said there's no magistrate.
To that I have to take instruction whether they are in the stations. Maybe they may be on leave also.
Leave, no leave, it doesn't matter. But it should be a magistrate.
In that way of the matter, let it come to my Lordship so that
Hmm?
I will take a proper instruction from the.
You're supposed to approach the magistrate, right?
Yes, Lord.
There's no magistrate
Yes,
in the entire district.
yes, Lordship.
Lordship, that is the submission advanced by the applicant, Lordship. However, that has to be a certain Lordship.
Offense? What is the offense?
Your Lordship, you was booked under Section 44A, NLTP Act, Lordship, NLTP Act, Lordship.
What is this? LLTP?
Yes, Lordship.
What is this?
Your Lordship, may kindly see my para 7, Lordship.
You don't know what is NLTP?
It was booked under Section 44A, that is for import and export any liquor.
I'm asking what is NLTP?
Nagaland Liquor Prohibition Act, Lordship.
Yes, you say so. You see. Just give me the LLTP. Nagaland?
Nagaland Liquor Prohibition Act.
Huh?
Nagaland Liquor Prohibition Act.
Is this non-billable? Hmm?
Your Lordship, as per the provision, there's no specific. My lord, however, for the first offense, the imprisonment is for 6 months, Lordship.
Hmm. Is this your third offense or second offense?
First offense, Lordship.
First offense.
Yes,
Should be valuable.
yes, Lordship.
What is this? Valuable?
Lordship. Lordship, if you go by this, it's valuable, Lordship.
Sure. Are you sure? We'll take up tomorrow.
Lordship.
You find out whether really there's no magistrate,
Lordship.
in the district. Find out tomorrow. If it turns out to be false, we'll impose cost on you, not the client,
Yes.
on the lawyer.
Lordship, actually what happened was that he was promoted and then he was transferred.
I don't know. I don't know.
That allegation is serious in nature, Lordship. Since the petitioner,
It's a serious.
Lordship.
No magistrate in the entire district. We'll take up tomorrow.
Lordship.
Be prepared for it. If there is, we'll be happy on you. All right. Not tomorrow, day after. No, day after is holiday. Okay, for this, we'll take up tomorrow. Tomorrow.
Tomorrow is division bench.
No, we'll take up tomorrow. We'll sit single. This matter. Tomorrow, that is 27. 9/20/20, so as to enable Mr. Busy Mohammed, let it public prosecutor to obtain instruction as to whether there is a magistrate or not in the district of Kipre.
Yes.
Prohibition. Item number 1.
Yeah, please, your lordship. Your lordship, here by the order dated 2nd May 2023. The honorable court has given some instruction. So your lordship, since the matter is very serious between the two commonwealths. So this time also we have referred to the cabinet. So we are waiting for this, and for which I received a communication from state respondent.
Last order? What was the last order?
Last order was dated 4/9/23. Here states for 3 weeks time to file it. Even on the previous occasion, 4/8/23, lordship, 4 weeks time was. So.
September, 4th September.
Yes.
What are you supposed to do?
Actually, as per the order dated 2nd May 2023, there is another court has given option number 1. That is, option number 1 is it was submitted by the one man inquiry. So we are trying for that. And again, the matter is between two communities. So we are also finding so many difficulties and hardship. So now, as per the direction of the report, we are trying our best. But the thing is,
If the state
yes,
is not able to resolve the problems between the two communities,
yes.
what we can expect?
Your lordship, of course, the respondent is very much aware of the magistrate of the court, but these issues very sensitive. That's why we are trying to comply with the
You
direction
take
of the honorable court.
If it is sensitive, you take it up sensibly
So,
so that things can be resolved.
your lordship, my humble submission is that in this nature of case, only the time can buy, only the time can solve the situation.
That-
Otherwise, we are trying our best to comply the direction of the honorable court. But because of the
Sir, that is very, very strange argument. A strange submission.
no, your lordship,
You want to buy the time to
No,
resolve an issue.
no, that is my
I'm
personal.
sorry.
No, that is my personal, your lordship. Your lordship, two communities. There are two
The
communities.
Land
involved.
Additional Advocate General, Mr. It's a two tenants to accept such a submission.
No, my personal, my personal.
State is making a submission to resolve an issue. The way out is only to buy time.
No, but that is my personal
Sir, I'm
observation,
sorry.
which is expressed to your lordship. My personal observation. And lordship here, the problem with us is, suppose if we just comply the direction of the honorable court without may hastily, then definitely there will be law and order problem will arise in the state. So we are very much aware. So we are in between. We have to see the direction of the honorable court at the earliest and at the
That
same
is
time,
another strange submission.
and at the same time,
That state should be in between. You have to resolve the issues.
yeah, we have to resolve.
Is it for the public or is it for the people, is for somebody else?
Your
state-
lordship, it is my duty to look after the welfare of the public.
Yes.
So that is my submission. So we have to see. We cannot ignore the direction of the Honorable Court. At the same time, we cannot ignore the welfare of the.
Therefore, you want to buy time?
No, so we are trying our best.
The only way out is they will do the
No,
buying it time.
we're trying our best. Actually, initially, it was advised to do one man inquiry, but it could not materialize. So because of which we have already given to the cabinet.
There's a report on in one man inquiry.
Yes. So in terms
You
of
act on the inquiry. What is there?
the option, one man inquiry.
That option A.
Yeah, two options are given. So your worship, by the order dated 2nd May 2023, the Honorable Court has given option number 1 to exercise by the state.
The action by the state has fallen from your mouth. Buying time.
Your worship, that is my personal expression.
Please, Lordship, the state has
We'll call
been.
the officer.
Your worship,
Lordship. In fact,
you see.
Lordship,
We are not interested in calling the officers, but this cannot be allowed.
your worship,
It's very, very surprising. I'm shocked.
your worship, I mean,
The court's order here, the state is buying a time.
no,
It has truly
You-
fallen
you-
from your mouth.
that is my personal expression,
Lordship,
expressed to your worship. That is my personal expression,
Lordship, in fact.
considering the.
Lordship will kindly-
That's not the case.
If you're first, it is your personal, and if you don't have an instruction from the authority, we'll call him. Let us see.
In fact, Lordship, if you may kindly peruse the order.
Yes, yes,
2nd February
I've seen.
23, Lordship. An order has already been passed, calling for personal appearance of respondent number 1 and 3, Lordship. Passed by, Honorable Justice Alice Jamir. 2nd February 23, Lordship.
Sir, court is not interested in calling the officers here. They have other business to do.
Your worship,
But then we're compelled if you take the things lightly.
your worship, I'm allowed to get a latest instruction.
Lordship, he has been seeking time to file an detailed affidavit to file the latest developments and the steps taken by the
Yes.
administration till now, Lordship. And he has been seeking time, but nothing has been filed yet. So at least, the least he can do it, at least file the detailed affidavit so that we can at least know what is actually going on. These letters, he has been producing one letter after another, but this does not suffice, Lordship.
Do something.
Your worship,
Mr.
I'm allowed to
Himself,
give instruction.
you're learned additional advocate general of the state.
Your worship, with your apology. So I may be allowed to file an affidavit in the next step.
How long you'll be taking
Because
adjournment of this?
your worship here, that
Do something. Act seriously.
definitely.
It might sound very harsh, but I'm sorry. Cannot be allowed to go on like this. Don't make, you said option 1 will be taken care of.
Yeah, we are trying for.
You have agreed. But thereafter, you are seeking so many adjournment.
Your worship.
Who is responsible? Chief Secretary.
Chief Secretary, Home Commissioner.
Should this call them?
Your worship,
Personal appearance.
before that, I may be allowed to file an affidavit.
Because you said the only way out is to buy time. So ask him, whether this is a, I mean,
Your
state of
worship-
affairs of the state.
Your worship, with your apology, it is my personal expression, expressed to your worship. Otherwise, there's no instruction from the state to submit in such a way that the time. But that is my personal, being a court officer. Sometimes I'm also compelled to express my personal view.
That is the whole difficulty is that being a court officer, you have to submit
My-
responsibly.
Yes, but my personal expression, observation.
With responsible, you have to submit.
Your Worship.
That too, you being the learned additional advocate general. It may sound very harsh, but no way out. Madam, what to do? Things has to be resolved,
Lordship.
and we don't get pleasure by calling them in the court.
Lordship.
One was supposed to. Everyone does have their own assigned task. We'll give you 2 weeks time
Your Worship.
as a last chance.
Your Worship.
Either you comply or next date you they have to appear to explain. Have you not getting support? I mean, the proper support from the administration?
No. I'm getting timely support.
Then what's
should-
happening? Why it's happening then?
Your Worship, as I submitted.
Why is this like
It
this?
is involving two tribes.
I understand.
Yes.
Forget about 2 communities. The report is there.
Yes.
You said you will act on the option 1. You have to act on it. That's all.
Option 1.
What is the difficulty? Heard Mr. MS so learned counsel for the petitioner. And also heard Mr. MT himself, learned additional advocate general. For the state, appearing for respondent, all the respondent,
All the response.
1 and 2.
1 and 2.
How many respondents? 2.
Lordship, there are 3.
Three. But I represent 1 and 2.
By producing a communication dated 25/9/2023. Very casual, this communication also. And they don't have a courtesy to address you a learned additional advocate general. And they not, that has not also been filled up. Only below the signature. Is it the way the communication is being made to you?
This time I received.
Do something. You are the advocate general of this state. What is that? Before this court submits that he may be granted some time as the matter relates to communal conflict at Seoul village under Kifre district. Which has been resubmitted to the cabinet on 4/9/2023 for its consideration and further direction. And such instruction, not Mr. As such, the instruction of the cabinet is still awaited, Mr. This court noticed that the matter has been dragging for so long to comply the courts order of this court under the pretext of some issue or other. which this court deprecates. However, in the interest of justice, Mr. Imti himself, learned additional is granted another 2 weeks' time as a last chance to either to comply the court's order or face the consequential proceedings thereafter. List this matter after 2 weeks. Will not grant you another any further time. Either you comply or face the consequential proceedings. All right. I'm sorry, it may sound harsh, but no way out. All right.
Item number 2.
Huh? Two. Yes,
Yes, Your
ma'am.
Lordship. Yes, Your Lordship, the present criminal relief petition was filed for direction to the state respondents to register FIR, Your Lordship. Here, the brief facts of the case is that.
What is the law on it? Lalita Kumar,
Yes, Your Lordship.
is there cognizable offense made out?
Yes, Your Lordship. Your Lordship, the offences committed against the petitioner, all cognizable offence amounts to under section 250, 326, 325, 451, 452, 457, 458, Your Lordship. And section 506 IPC.
Lordship, I think there's still avenues to explore, Lordship, before coming to before the Honorable High Court.
Nothing, Lalita Kumar, Lalita Kumari.
Lordship.
If a system discloses cognizable offense, you have to register, no way out. There's no requirement of filing a petition before SP also. If it establishes or discloses a cognizable offense.
Lordship, such is not yet so far.
You have to read on the face of the FIR. Who is for is there private respondent?
Yes.
What is this? No, you just wait. You explain why. Why no registration?
Lordship, 2 inquiry has been conducted.
Huh?
2 inquiry has been conducted, report has been submitted, but there's not
According to you, it doesn't disclose a cognizable offense.
no, Lordship. So affidavit has also been filed, Lordship.
No, make a submission, oral submission. Will come later.
First inquiry was
Inquiry conducted.
yes, on 7th,
According to, there's no offense made out.
Lordship.
Huh?
Under which section they are to be booked? That is not method, Lordship.
Huh?
Under which section of law they can be booked on the
Police doesn't know how, under which section
no,
of
because
law it has to be registered.
no, Lordship, because as per the investigation,
Huh?
as per the investigation, Lordship,
Yes.
the investigation could not make out the exact nature of the offense was committed as alleged, Lordship.
Very poor. Very poor thing.
So my next shift one was made on, and my next year, Lordship, on 6 sub year.
Huh?
Next year.
Yes. Affidavit,
Correspond number 2 and 3.
2 and 3, yes. Voluminous affidavit. It's bigger than the writ petition, at the criminal petition. Just which page?
Relevant parts is at page 54. Lord Chief.
54.
Yeah, page 48, but relevant portion is page 50.
Yes.
Second paragraph, Lord Chief. In the
Yes.
In the course of inquiry, the complainant stated in his FIR that some men numbering around 20 to 30 came to Mrs. Senso house while he was sitting along with his friends and beat him up and his friends without any rhyme or reason. But while recording his statement, Havildar Income Concept, that is the petitioner, stated that around 10 of them entered inside the house and kicked him while he was sleeping and dragged him outside the house. While recording the statement, Havildar Income Concept also stated that none of his friends were beaten, harassed, except one of dire consequences if found indulging in political activities. The statement given by Havildar Income Concept during the inquiry is found in contrary with his written FIR. While recording the statement of Havildar Income Concept on census date at Police Station 2, Bukokchu, no external physical injury was noticed.
Who's this Hemkong Suk?
Petitioner Lordship.
Hmm.
The medical report, which was submitted by Havildar Income Concept petitioner, dated so does not mention any injury to his body. Next, no criminal cognizable case to be meted out during the thorough inquiry, since there is an FIR lodged from both the parties with allegations and counter allegations. There is likelihood of breach of peace and tranquility in the village and within the villagers. So that is a second inquiry located. The detailed report. So
Thereafter,
thereafter, the case was submitted to magistrate also.
yes.
Executive magistrate page. Page 58. Type copies, next page, Lordship, page 59. 58, next page. Shall I read, Lordship?
Yes.
Whereas a non-FIR case number so dated so was received from the officer in charge, police station 2 Mokokchung to the undersigned, along with the 5 alleged accused person, namely Senso. In regard, last second line of the first paragraph, in regard to the complaint filed by Sri Income Conserve, Havildar, second NAP Battalion Ali Chen. Second paragraph, whereas the inquiry officer ASI Senso, after thorough investigation, submitted the report to the OC Police Station 2 Mokokchung, wherein he stated that no offense meted out in the complainant could be established after thorough investigation and taking into consideration all evidence and witnesses, facts and circumstances against the 5 alleged accused persons. Thereby the OC Police Station 2 Mokokchung registered a non-FIR Senso under section 107 CRPC and forwarded the above case to the undersigned along with the alleged accused persons to execute a bond for keeping peace and public tranquility. Whereas on examination by the undersigned of the report submitted and also all the 5 alleged accused person and the 5 witnesses produced by the IO, ASI Wati Lemba, no concrete evidence was surfaced established to the commission of the offense to put this person under appropriate section of law. On further examination, the statement given by the alleged accused person and the witnesses corroborated with the statement given to the IO ASI Wati Lamba. However, a counter FIR in which is under investigation by police, PS2 Mokok Chumbasin also noted. Thus, in view of the prevailing situation and the activities, there is likelihood for breach of public order, peace, and tranquility in the village and among the villagers. Now, therefore, keeping in view of the above facts and circumstances, and in exercise of power conferred under section 107 CRPC, I3 so EAC Opang Pong, Executive Magistrate, hereby order the 5 alleged accused, namely so to execute a bond for a period of 6 months from the date of issue of this order to keep amending public order, peace, and tranquility law. So this has been the situation locally.
So, madam, there's nothing.
So in support of my submission, lawfully, I would like to place
There was an inquiry.
Yes, your lordship, on 14/7/2022, when the petitioner was summoned to the police station, he has shown his injury marks to the IO of the case, your lordship. Which I have also annexed in my affidavit in reply to the affidavit, to the counter affidavit filed by the state respondents, your lordship.
Just wait.
lawfully,
What is this?
2008 USCC 409 lawfully.
Hmm.
The relevant questions of law, lordship, allow me to cite page, paragraph 25.
Sakira Basu. Where?
Paragraph 25, 26, and 27 lawfully. Paragraph 25. We have elaborated on the above matter because we often find that when someone has a grievance that is as
No. Thereafter, Lalita Kumari. 2014. Yes, madam.
Yes,
Lalita
Yes, your
Kumar.
Your lordship, I have produced in my affidavit in reply, your lordship.
Lalita Kumar, judgment of the Supreme Court,
Yes, your lordship.
2014.
Yes, 2014 to SSC 1.
According to you, if you have a grievance, you have to approach the concerned magistrate.
yes,
That is what you are trying to say.
or can file as per this ruling of this Supreme Court, he has the option to file a criminal complaint under 200 CRPC. Petitioner still has the option of approaching the magistrate, or if that is also exhausted, he still have options under section 200 CRPC.
So no writ can be filed for registration of FIR. According to you.
No, this is the development thus far, Lordship.
Huh?
This is the development so far, Lordship. The investigation has been
No, by relying this Sakira Basu, we are trying to say that the writ is not maintainable. I mean, this petition is not maintainable.
not maintainable.
For registration of FIR.
Because as per, to approach a direction under 482 Lordship.
482 may not be there. Why don't you file a writ petition? What is criminal petition? Not 482. Incident happened when?
9/7/2022, your lordship.
22.
Yes, your lordship. And the petitioner has filed their FIR on 10/7/2022.
Allegation is that they came to your house,
Yes, your lordship.
dragged you out, beaten you up.
Yes, while I was sleeping at my aunt's place. your
Is there
lordship.
any personal enmity?
Your lordship,
Personal enmity between you and those people?
lordship, it is the allegation that the petitioner, he was talking about politics in the village, Your Lordship.
You settle the matter. What is this?
Your Lordship, they came at night around 10:30 to 11, Your Lordship. While I was sleeping and physically assaulted me, Your Lordship.
After 2 years, I mean, nearly 2 years or more than a year, do you really seriously want to pursue?
Yes, Your Lordship.
It's a outcome of the election thing. Is it
Yes, Your Lordship.
outcome of the election?
Yes, Your Lordship.
Of course, we should not take it lightly, but then at the same time, are you not relatives, co-villagers?
No, yes, we are.
Settle, what is there? It's outcome of election, it happens. Try after 5 years again. Off the record, I'm saying.
No, Your Lordship, it is my humble prayer that
We'll take after a week. You think over it.
Your Lordship.
All right.
Yes, Your Lordship.
He is raising the maintainability issue also. You could have approached this court under Article 226, not 482. All right.
Yes, Your Lordship. And kindly allow me some time, Your Lordship.
And there's already an inquiry has been caused, and there's a report, and it was placed before the court. Court has taken note, I mean, cognizance of it, and then passed an appropriate order. Had it not been the outcome, I mean, arises out of that election and all, the matter would have been different. That's why I'm asking, is there any enmity or are you a co-villagers?
We all belong to the same village, Your Lordship. It appears that, Your Lordship, the police is also influenced by some outside elements.
Engage a dialogue with them and have a peaceful coexistence among yourselves. All right. And the criminal cases is both sides should be affected, both sides. Unless it is so serious or kind of heinous crime. After 2 weeks, you think about it.
Yes, Your Lordship.
All right. But MS so learned counsel for the petitioner, and also heard Mr. Keangam LNPP for respondent number 1. And you are for?
Respondent number 4. Lordship, I'm for 1, 2, and 3. Lordship.
1, 2, and 3. You are for respondent number 4.
Yes.
Mr. Shrins for respondent number 4. On the prayer of the council for the this matter after 2 weeks. Think about it.
Bless you.
May it please, my lord.
Yes.
I have the consent of the leading counsel for the private respondent, my lord. If it can kindly be listed on Monday,
Monday.
my lord.
Mr. Senti Agner learned counsel for the petitioner.
My lord, I'm informed that Monday is holiday, so if you can come up the next day.
Consent of the learned counsel for the petitioner. List this matter on 3/10/2022.
Deeply obliged, my lord.
Item number 4.
Next, Lordship.
Yes.
Lordship is a petition, application for question of the criminal proceedings before the below by district, Lordship. Lordship, the parties have entered into the next compromise, Lordship. But there are 2 sections. These 2 sections is for imprisoning an officer. No doubt both the sections are non-compoundable, but Lordship, the authority of the apex court is that even non-compoundable sections
Is it joint petition?
No, no, it's not joint petition, Lordship.
Hmm.
Not joint petition, Lordship. The complaint has been made respondent. The respondent has the complainant has filed a affidavit saying that yes, Lordship, the parties have entered into an agreement, Lordship.
Where
That's
it
what
is?
Lordship, the affidavit in opposition that is filed by the respondent. The compromise is at the page 20. Page 20, Lordship. Annexure D. Lordship, I'm appeal to it, Lordship.
Yes.
Agreement. First party, Mr. I think the petitioner, and the second party, Mr. Lordship. Lordship here. This agreement is carried out between the two parties on this day, the 29th May 2021, at the residence of Mr. Dr. So-and-so, parent town. Whereas the first party referred to as Mr. So-and-so, herein and apologized that he is responsible for writing and signing the resignation letter of Mr. Dane Ndang, that's the respondent, from the post of GB of Ndang Kale Parent Hall on 10th April 2021 is to be treated as null and void. Hence, the matter for removal of Mr. Dane Ndang from the KLGB and to be replaced by another candidate to the state oath due to his forged signature should stop processing it at the government level. The second party referred to as Mr. Daniel Ndang, the complainant, having heard the mediators agreed to forgive the first party and the complaint letter / FIR lodged to the complainant authority on 23rd April 2021 in his name.
Where is the Ramsingh Hega who has filed, who is the informant?
Lordship, he has passed away, Lordship.
Is it?
Lordship, that annexure is yes, Lordship.
Okay.
That annexure is 21. Annexure E, page 21.
Okay.
Lordship.
Obviously, if there is a compromise, you will not have any objection. What do you say? Huh?
No objection.
Okay.
Lordship,
Mr. Posiko, counsel to the petition, also heard Mr. K. Angami, Leonard Pepe, Nagaland, and Mr. Pullo,
Yes, Lord. Correspondent number 2.
who respond number 2. By filing this application under section 482 of CRPC 1973. The petitioner has paid for washing of the criminal proceedings in GR case number.
14 of 2021.
What is the GR case number?
14 of 2021, Lordship, page number 2. Because title, Lordship.
GR case number 2 of 2018
14 of 2021.
under section 170 and 465 IPC, 1860. On the basis of the compromise entered between the petitioner and the respondent number 2. Next period. The yes in nutshell. Is that an FIR dated 23/4/2021 was filed by the respondent number 2, jointly filed by the respondent number 2 and one late Ramsingh Hega, alleging that some individuals have impersonated them by posing the signatures and using their official seal for their own self-interest in the form, namely form for replacement of GB and letter of resignation from the post of GB. Ndang Khel. Huh? It is Ndang Khel or Dang Khel?
Ndang Khel.
Endangkel.
Endangkel.
We call it Endangkel.
Endangkel.
Endangkel. It is the next paragraph. Contents of the petition and the. In fact, that someone had filed form of replacement of GB impersonating the head GB within bracket. This is to replace a GB, and a letter of resignation impersonating the complainancy, and next paragraph. On the basis of such complaint, the petitioner was arrested, and he confessed that it was his doing, and he tendered an apology from the complainant, after which a peace agreement dated 29/5/2021 was executed between the petitioner and the respondent number 2. Thereafter, the charge sheet was filed. When? The police
Page 23.
filed the charge sheet
Page
on when?
Charge sheet was filed on 24/7/2021.
Charge sheet
Okay, page 23. Next to G. The last page, Lordship.
on 24/7/2021.
24/7/2021.
And what is the stage of case? Charges has been framed,
No, Lordship.
just a charge sheet.
Charge sheet is filling and is for payment of CC.
Which is pending for consideration of charges before the learned judicial magistrate, first class,
Lordship.
judicial magistrate first class, parent. Mr. Next paragraph. The learned counsel to the learned public prosecutor and the learned counsel for respondent number 2 has no objection if this court interfere and process the criminal proceedings, as there is likelihood of there is no chance of the chances of conviction are bleak in view of the compromise agreement that in view of the agreement between the informant and the petitioner accused. But then once you have confessed and it's a case of forgery, impersonation, it is established. So there is chances of conviction are not bleak. Even if you don't, if the PWs turn hostile, you'll be convicted.
Lordship. Since they are from the same
Anyway.
same scale.
Having and then considered I have considered the submissions of the learned counsel to the petitioners, learned counsel to the parties, and where is the materials available on record. Do you have the
Lordship.
LCR? LCR. Listen. This court, next paragraph. Take note of the agreement entered between the respondent and petitioner and respondent number 2. Dated 29/5/2021. Wherein the peace agreement has been executed, stating that the petitioner had admitted and apologized that is responsible writing and signing the resignation letter of the respondent number 2 from the post of GB of N Gadang Kelpere. Then it also appears that after subsequent to the peace agreement between the petitioner and the respondent, the respondent has submitted a letter dated 31/5/2021 for withdrawal of FIR dated 23/4/2021 before the officer in charge, police station parent, praying for withdrawal of FIR on the ground that the matter was amicably settled amongst the parties in the absence of dispute. Further proceedings may be futile and unnecessary. Next. The police has already submitted the charge sheet. Under section 170 of the 465 of IPC. And sent the accused for trial, for which consideration of charges, which is at the stage of consideration of charges before the London JMFC parent. Next,
It's a CGM.
CGM. Then you write CGM, Chief Judicial Magistrate parent. The next parent. In the case of, what is that? State of Madhya Pradesh versus Lakshmi Narayan.
Lakshmi Narayan Lordship. 2019.
Versus Lakshmi Narayan, reported in 2019.
5 SCC.
5 SCC.
688.
688.
Lordship.
Paragraph 15.
Paragraph 15 Lordship.
The Supreme Court has held, which is reproduced here in number. You just give paragraph 15, huh? Lordship. Next paragraph. Having considered the submission of the learned counsel for the parties and the parties and the fact that the parties have entered into an agreement for which, in view of this court, for which, in view of this court, there is the chances of conviction is bleak, and the parties have decided to settle the issues for their future peaceful coexistence. Therefore, this court is of the view that this is one of the cases where this court would invoke the inherent power under section 482 of CRPC. Accordingly, in view of the above, and the law laid down by the Honorable Supreme Court, is the criminal proceedings in GR case number 2 of 2021.
GR is 14 of 2021. GR is 14 of 2021. And police case is 2 of 2018.
No, it's okay. Criminal proceedings in GR case number
2021. 14 2021.
GR case number 14 of 2021, corresponding to parent police station, case number 2 of 2018. Pending before the Chief Judicial Magistrate parent is hereby set aside and quashed. petition disposed of.
Are you like?
Item number 5.
May I please, your lordship?
Yes,
Lordship, 4 weeks may be granted. As negotiations between the two parties are going on for amicable settlement.
what is the issue?
Questioning and setting aside of civil suit.
Huh?
Questioning and setting aside of civil suit 1/2022.
Civil suit. How can there be how can we quash the civil suit?
Lordship, a civil suit and a
What
criminal.
is the dispute? Land dispute?
No, lordship. No, it's about a case, a civil case was filed and a criminal case was filed over the same cause of action. Your lordship.
Okay,
We're not denying the liability of this case.
huh?
We're not denying the liability, but there is no criminal intention. So there's no criminal intention.
Okay. So you want
4
4
weeks.
okay. Then in that case, why it's a criminal revision? 482,
Yes, Lord. The criminal entry.
4 weeks.
4 weeks time, lordship.
Mr. So MS so and so learned counsel for the period and also Mr.
I bring on behalf of.
Pakin
RL
Sito.
Yeah, on behalf of RL issue.
So and so, so and so.
Lordship, there's an interim.
MS so and so learned counsel for the learned counsel submits that. The endeavor are being made to settle the matter, amicably settle the matter outside the court. For which she prays for 4 weeks time. So just prayer not being opposed by the land council with the respondent. Come on. Praise the Lord. This matter after 4 weeks. So as to enable the parties to settle the matter outside the court. This
Lordship, there's an interim.
interim order earliest was shall continue.
Much obliged.
Item number 6.
May I please, Lordship?
Yes.
Lordship, I'm for rest number 1. Lordship, if Lordship with Kalidarity registry to call for LCR.
Okay.
Next day, Lordship, we can hear the matter, Lordship.
LCR will be required.
LCR will require Lordship.
First appeal.
Lordship, it's a bit.
Has it been admitted?
No, Lordship. No, Lordship. No, Lordship.
Parties are all parties represented.
In the first
Okay.
it's of the parties were all present. They filed caveat.
Lordship may admit the appeal and
Are Mr.
forfeit.
Sentient and counsel for the petitioner. Yes, you are for. You are one in
One.
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 For sake of for respondent number 1. And Angami for respondent number 3 to 6. Who is for 2? You are for 1 and 2, I suppose. For sake of the, you don't have the brief.
I'm from 1. Lordship, brief is taken by my senior one. But I'm for the 1 and 2 is the village council. Notice.
Village council is required.
They are mere performer respondents, my lord. Even the state is performer respondents only. My lord.
But then since you have implemented them, you take steps.
Yes, lordship.
Mr. So and so learned counsel for the petitioner shall take the steps for service upon respondent number 2.
Yes, lordship.
Where register post within 2 days. Call for the LCR.
Lordship.
List after 4 weeks.
My lordship. Lordship, there's an interim.
Interim order was earlier still continue. Status quo.
My lord.
Status quo.
Yes, my lord.
Bless my Lord.
Item number 7.
Yes, notice office note reflects that Office note dated 26/7/2023. Huh? You are appearing for all.
Lordship, I'm for one.
Huh? You are for one. You?
I'm for one.
Who's
I'm
for one?
2 and 3.
2 and 3.
And
Three
Two and three.
contemners.
Lordship, and 4 is Mao Yun-chen is appearing, Lordship.
Huh?
Mao Yun-chen.
Wait, Mao Chen.
Lordship.
Mao
is,
Yun-chen.
On leg in court number 1, Lordship.
What to do today?
A week's time may be given so that instruction has been received by respondent number 4, Lordship. He will be
Okay.
filing an
He's the one who has to comply.
Lordship. So he will be filing
Mr. So-and-so learned counsel for the petitioner.
respondent 1.
Also heard Mr. B.G. Momi, learned counsel. For Alice contender number 1.
No, 2 and 3.
Huh?
I'm for 2 and 3.
2 and 3.
That is for respondent.
And I'm lobbying for respondent number 1. 4 is for Moim Chen.
Mao Yun-chen.
Moim Chen for respondent number 4.
4.
Mr. B.G. Momi, learned counsel to the learned counsel submits that he may be granted 1 week time to obtain instruction. Praise the Lord. List up to 1 week.
Yes, may I please, your lordship.
Yes,
Your lordship, this is in regard to releasing of seized vehicle of the month.
release it.
Lordship, I have received the.
What is, what is there? Have you released?
No, Lordship. Not in this Lordship. Lordship, the real owner is not a certain thing that Lordship. That is what the status report says.
We'll identify this. That who is the real owner.
Lordship, since the real owner is not, till they're not a certain Lordship, as per the investigation Lordship, by the investigating agency Lordship. So it is now becoming difficult to release the safe vehicle Lordship.
Huh?
Now it becomes difficult for to release the safe vehicle because there are no real owner has been identified. Yes, sir.
Are you assuming the role of civil court?
No, Lordship, no Lordship.
Hmm?
Lordship. That is what it says in the status report. Lordship. I'll leave it to your Lordship.
My lord.
Police says they could not identify who is the real owner.
My lord, even on the last occasion, they have stated in that line. However, after a lapses of 2-3 months, there is no progress in the investigation. Now, your lordship, it is the duty of the.
You have seized the vehicle
Yes, Lord.
without further any investigation. When you were asked to take the instruction, you just said so. I mean, you are giving, not you, but the police, IO.
Lordship.
Release it immediately. Next, example. Heard Mr. So-and-so, done it consent to the petitioner. By filing this application, why 482? And 451?
Your Lordship, I have approached, read with 451 of the CRPC.
What is 451? CRPC. In that case, you go to the criminal court. Petition doesn't like, think over it. Have you gone to the criminal court? Under
Yes,
451?
yes.
Where it is?
Your Lordship, you can see my annexure 4 at page 14, Your Lordship.
Hmm?
Annexure 4.
Yes.
14.
Yes.
This is the rejection order, Your Lordship.
It's okay. If you cannot find out, we'll release, I'll direct you to release. All right. By filing this application under section 482 of CRPC 1973, the petitioner has prayed for release of Maruti Alto LXB SIB. Page 1, huh? First, thing. Which has been. When it was seized?
4623, Lordship.
Seized on 4/6/2023. In connection with the East PS case number 144/2023 under section 279/304 within bracket capital A IPC read with 181/183 within bracket 1 bracket close /184 Motor Vehicles Act. The petitioner, the contents of the projection made by the petitioner is that the petitioner is the real and genuine owner of the vehicle bearing What is the vehicle? This Alto?
Yes, Lordship.
Genuine and real and genuine owner of the Maruti Alto LXB BSIB bearing registration number IA. What is IA?
12, that is 12.
Huh?
ES 12, Lordship.
What is the registration number?
Registration number is AS 12J,
What it is?
page 4, paragraph 4.
Page 4.
Paragraph 4, Lordship.
Registration number is 12J2489. And engine number so and so, page 4, paragraph 4. Which was purchased by her. From where you have purchased?
Lordship, I've purchased from Assam, Lordship.
From whom?
Your Lordship, I've purchased the said vehicle from Assam second-hand showroom, Your Lordship.
Huh?
Assam showroom, Johat showroom,
From Assam, from the state of Assam. Which place?
Johat, Lordship.
From Jorhat, Assam.
It says here, Silsagar. Page 13.
Page 13.
Government of Assam, Export Department. Page 13. On top.
This is Sibsagar.
Yes, Lordship.
Jorhat is in Sibsagar.
Actually,
No, your
Lordship,
credentials are doubtful.
Your Lordship, here
I thought I'll just release it.
Your Lordship, they have already issued the NOC, and then even as per the,
You said Jorhat, and you said sometime you said auction, and you said it's so your document shows Sibsagar.
no, Lordship, here,
Credentials are very doubtful. Let them find out who is the real owner. I'm sorry.
you-
You are not able to establish.
no,
Is it from Jorhat or Sibsagar?
Your Lordship, the petitioner had bought from Johat second-hand showroom. Now, the Johat second-hand showroom, they used to collect, they used to buy
It's
from,
no doubt. Second-hand showroom and all those things.
Your Lordship, even the concerned department has also already issued the NOC, Lordship, and then even the registration card, it is also in the name of the petitioner, Your Lordship. Your Lordship, mechanism my annexure 3, page 12. Even the NOC has already been issued, and then even
But
the,
is it purchased from Jorhat or Sibsagar?
she had purchased from Johat.
Ah.
But then since this registration number, it comes within the Sibsagar, the concerned district, they used to give the NOC, Lordship. And then even the NOC is issued. Now, even in the RC, even the names has already been given under her name, Lordship.
Credentials are doubtful. You are not able to establish. Had Mr. So-and-so learned counsel for the petition. Also had Mr. BJMO learned counsel, learned public prosecutor. Mr. BJMO learned public prosecutor produced the status report as directed by this court and submits that the police could not establish and find out the real owner of the vehicle in question. Therefore, it may not be appropriate to release the vehicle at the instance of the petitioner at this stage. The investigating officer is directed to identify the real owner of the vehicle expeditiously by causing proper investigation. Let them come up with this list after 3 weeks. All right. I thought I'll direct them to release, but you are not able to establish the real, your credential itself is doubtful. Maybe you are not able to communicate properly. But it's Shivsagar and Gauhati, this is something, I think different place or it is same place?
Your lordship, it is within the Assam, but different place, lordship.
Different place.
Yes.
I know it's within the Assam.
Yes, yes,
That's why I'm asking.
yes.
I know Shivsagar and Gauhati,
Yes.
where it is. I've been to there also. That's why I'm asking, is it the same place, same thing or same place or different place? You come prepared, all right?
Much obliged.
Item number 9.
Sir, what is this?
This is with regard to suspension of the GBs by the deputy commissioner.
Yes.
In exercise of the power conferred under the Nagaland Village Council Act. Village Council, they have a separate notification as far as the appointment, the service continuity is concerned. But because of the allegation on the village council that there has been some misappropriation, the present petitioners, they have been suspended there. Under no provision of law. Now, the private respondent, they have filed the affidavit. I finally replied to that. State, despite the passage of more than 11 months, they have not filed an affidavit.
You are not filing?
Lordship will be filing lordship in the Lordship. 2 weeks time may begin.
Lordship, Lordship, what has happened is the private respondent, they have filed an IA seeking a direction for constitution of the village council.
By this IA?
By IA,
This is the present IA?
the present
You
IA.
will hear the entire matter.
Yes,
Who is holding? Who is in the chair?
the
Who is functioning?
EAC.
It's okay, we'll hear it. We'll get 2 weeks time. Therefore, if the government is not finding it urgency, what can we do?
Lordship, urgency also on me, Lordship, because I have been suspended illegally. And now, Lordship, what is
How the process of appointment? GB?
Yes,
Under what provision?
Lordship, there's a notification
Whereby
Lordship, I have annexed.
it's okay, you just tell.
Yes.
You just tell
It's a
me the,
notification of
you
neither
just tell me the procedure. We'll be granting 2 weeks time.
appointment is, you should be a citizen of that village. Attain age of 35 years. Fulfill the customary practices of the plant villages. These are the requirements.
You have been suspended.
Yes. By
And
the order of the deputy commissioner.
in your place, they want that there should be appointment process.
We are a body under the village.
Unrecognized body.
We are the social welfare party, students, women organizations.
Who select the GB?
GP has been appointed and selected by the former officials
No, government.
and basing on which the government has appointed them. But during the process, during the work, so many mismanagement, misgovernance was found out. So the body commissioner has suspended the petitioners
On your representation,
Yes.
on your complaint.
on my complaint.
Okay.
It's Suspended.
Was there any hearings to him before
No.
suspension?
No, no,
Report will stay.
yes.
After the suspension, the body commissioner has issued a direction to the petitioners, suspended chiefs
To so cause.
to produce documents
Okay,
Produced the comment. But they are not in a position to produce all the documents as required by the Deputy Commissioner. And on the basis of which the Deputy Commissioner is also support,
they have misappropriated something, some fund,
very much,
huh?
very much.
Is there any criminal case pending?
No criminal case, but
Then-
they have applied for RDI. RDI report speaks about some.
You file a criminal case unless they are proved guilty.
Here, we are.
If their guilty is not established, how we can jump the gun that they have misappropriated? You have not filed any criminal complaint against them?
Here, I'd like to highlight one fact.
Yes.
The authority concerned, respondent authority, state authority, they are supposed to initiate a proceeding, disciplinary inquiry. But I don't know how far the state has initiated to that extent. Now it's more than 1 year without a village council.
Yes,
How we can exercise?
yes.
And it's given under the care of ESA. ESA cannot overall function as a
Government
village council.
government is happy
So
that they are,
the government be directed to file the affidavit
they,
within 2 months because
they
have
ask,
taken sufficient time.
they assume your power, they are happy.
No,
Very interestingly, the organizations who are unauthorized, not a registered body, they are working in connivance with the government, Lordship.
no. You
Lordship,
file a complaint.
Okay, it's okay.
we have lots of complaint, Lordship. I'm ready to file, but since the state is not filing, we have lots of complaints for the.
Which time may be given to?
As a last.
Not Mr. So-and-so, London Council for Deputy, Mr. So-and-so for respondent. Respondent number,
I think read petition is from 6 to 11. And IEA, I'm the petitioner.
you just record his name first. Mr. B. Jimomi for respondent, state respondent. And or it's okay. In main case. Mr. B. Jimomi, London State Council submits that he may be granted 2 weeks time to file contract. Raise a law, list after 2 weeks, so as to enable Mr. So-and-so to file contract.
Lordship, if no affidavit is filed, the matter may be heard, Lordship, because we are suffering. Means the petitioner's law, because being lawfully appointed. Any action,
But then you are governor, why you have misappropriated the fund?
Lordship,
Is this the allegation?
allegation is but without any facts and figures.
Okay.
Every government is with the government.
Government, you file? Okay. After 2 weeks.
Orders, item number 10.
Maybe Lordship.
Yes.
Lordship has put his honorable court's direction. We're taking steps upon response 1, 2, and 3. Lordship, there are some-
Take first step. It says no such person in the address.
Lordship. Oh, 1 to 3, Lordship. 1, 2, and 3. 1 and 2 are the UGC.
2 and 3.
1 is the ministry. One is the Ministry of Human Resources Development. 2 and 3 are the chairman of the UGC and joint secretary.
Where it is?
Actually, page number 2 of my contempt petition, Lordship. Page number 2. 1 is the ministry. 2 and 3 is Lordship, they're the chairman and the joint secretary of the UGC.
It's
Lordship, here, Lordship, this matter.
They might have changed
Yes,
by now.
Lordship, this is the 2016 matter. So Lordship, kindly let
You find out the
Lordship. Well, ascertain the
person concerned and
person who's holding the post and will
Office.
impede.
Art Mr. So-and-so, the council for depression. Office note reflects that, office note dated 18/9/2020 reflects that. Notice upon respondent number 2 and 3, return answer with a remark that no such person is. Not such person in the address. List of in view of Mr. Fosiko, but the learned counsel for the petitioner. Is granted 3 week time to ascertain
To file applications.
the ascertain the name of the Alice contempt. and file appropriate
Lordship.
applications, appropriate application, and for appropriate steps.
Lordship.
Item number 11.
Made this lordship.
Yes,
Lordship, as per the order dated 4/9/23, I have taken fresh steps. However, Lordship, as per the office note dated 13/9/23.
service report awaited.
So the service is still.
Had Mr. Insulant consent to the appellant. Service reports, office note dated 13/9/23 reflects that the service report. Service of notice upon respondent number 2 is still awaited. List this matter after 3 weeks.
Much or much.
Item number 12.
Next, Lordship, as per the order of this honorable court dated 28/8, are taking steps on 29th upon respondent, source in the respect of our Lordship.
Hmm?
The respondent is the Bank of Baroda. Taking steps, Lordship.
You'll take steps.
We have taken steps on 29/8,
29/8.
Lordship.
Okay, then we'll wait for some time.
Lordship. After 2 weeks.
Office note dated 308/08/2023 reflects that service of notice upon respondent number 1 is still awaited. List this matter after 3 weeks.
This is the interim.
Interim order was earlier shall continue.
Item number 13.
Yes,
My service report is awaited
service report on, I'm a so and so.
in respect of respondent number 1.
Heard Miss MS so and so learned consent for the petitioner
Yes,
and also heard BG Momi learned PP. Office note dated 21/9/2023 reflects that the service of notice upon the respondent number 1 is still awaited. List after 4 weeks.
my lord, interim order may be continued.
In order earlier first shall continue.
Deeply obliged.
Item number 14.
Please, my lord.
Yeah,
The service of notice upon the respondent number 2 has been completed on 20.
office note dated
I have filed affidavit, my lord, according to
Huh?
yesterday.
you have filed, you have taken steps.
Yes, my lord. By way of custody service, I filed by affidavit yesterday. I don't know whether. it
It's
is-
okay, we'll wait for some time. Huh?
Lordship.
Office note dated 21/9/2023 reflects that service of notice upon respondent number 2 is still awaited. List this matter after 3 weeks.
Lordship, the,
Interim order passed earlier shall continue.
my lord. Keep your mind.
Item number 15.
Lordship.
Have you taken steps?
Yes, Lordship. Notice.
Office note dated 13/9/2023 reflects that the service of notice upon respondent number 2 is still awaited. This after 3 weeks. Interim order passed-
1 week.
Huh?
I want 1 week time may be granted, Lordship.
Okay, you are for petitioner.
Yes, Lordship.
This after,
Lordship, I'm waiting for respondent number 2.
huh?
Respondent number 2.
Is a paper respondent number 2.
The seat.
Huh?
The seat. Respondent number 1.
1. Okay, you are for 1,
Number 2.
2. So he
Lordship,
he entered,
I may be allowed to file a reply to the counter affidavit filed by respondent number 2.
you have filed a counter affidavit. Huh? It's not here. We'll take up after 1 week. Heard Mr. So and so, let us consider. Mr. MS so and so. PP port respond number 1. Mr. What is, learned counsel for the petition? Learned counsel appears for respondent number 2. Who submits that he has already filed his counter affidavit.
Lordship, I have an
Mr.
interim.
So and so. Learned counsel for the petitioner.
Lordship, I have an interim.
Read for, yes. First for grant him in 1 week time to file his reply to the counter affidavit. List this matter after 1 week.
Lordship,
Interim order was earlier shall continue. Yes.
or hearing, item number 16.
Please, your lordship.
Yes.
Lordship, I'm appearing on behalf of my seniors, Mr. Citizen.
Where is?
Is the other court for
Okay.
an urgent partner matter, which is
Okay.
going on right now.
So on the prayer of the MS Swainso, learned counsel appearing on behalf of Mr. City Zamid learned senior counsel submits that her senior Mr. City Zamid senior counsel is engaged in court number 1 in a very urgent and hot matter. Stuff. Therefore,
3 weeks time, lordship.
for which she prays for 2 weeks time.
3 weeks, lordship.
3.
Yes, sir. Lordship.
This will continue
Yes, it's
for 3 weeks. The hearing will continue for 3 weeks.
Yes.
Then it's a very nice excuse for adjournment of the matter. No urgency.
There is, my lord, but.
Who is in the
Let it be. Let it be changed. Because.
who is in the better wicket? What? Mr. Imti Langzat, learned counsel for the respondent.
Yes.
Has no objection. Mr. Prayer is allowed. List this matter after 2 weeks. Hopefully, the argument will complete by 2 weeks.
Much obliged.
Item number 17.
Wait, please, my lord.
After 4 weeks.
No, my lord. Actually, my lord, I have another hearing item, last item. There is some urgency in that case.
Huh?
In item 24.
On the prayer of Central Young Learned Counsel for the petitioner, list this matter after 6 weeks.
No, my lord.
Huh?
Tomorrow, lordship.
4 weeks. Tomorrow, how it? Tomorrow is
Then on Thursday, my lord.
Thursday holiday.
Thursday,
You
the.
come to chamber, I'll hear you.
Lordship, then on Tuesday.
After 2 weeks.
Simply obliged, lordship.
Item number 18.
After 4 weeks, on the prayer of Mr. Swainso, learned counsel to the appellant. No, but not appears for the, you are here, yes. So he's also seeking time. No issue. Oh. On the prayer of Mr. Swainso, learned counsel appearing for the appellant. List this matter after 2 weeks.
4 weeks.
4 weeks. 4 weeks.
We also got the paper books on receiving.
Mr. Imti Longzeb, learned counsel for the petitioner, learned counsel for the respondent present. List after 4 weeks. Same.
Item number 19.
Well, lordship, on behalf of Ms. Sokre, she's not well, not presently.
What happened?
Suspected.
Is she
Yes.
really
Yes, Your
not
Lordship.
well? Okay.
So if you can list the matter on maybe 16th of October.
October. Mr. So-and-so for petitioner. And empty Longzem for learned counsel for respondent. And you are for? Mr. So-and-so, learned counsel for the learned state council. Are you a state council?
Yes, Your Lordship.
Learned state council. Submits that his senior MSB Sokri learned addition who is appearing in this matter on behalf of the state is not keeping well. They profess for listing the matter after 2 weeks, 3 weeks. on 3 weeks. Prayer is allowed. List this matter on 16/10/2023.
I'm not getting an opportunity to bet on this wicket.
Huh?
I'm not getting an opportunity to bet on the wicket.
Yes, yes. I would love to.
Item number 2.
But then one thing, this system has to be little improved
Yes, this is true.
by having a dialogue amongst the
Bonds.
bar members as well as the registry. Otherwise, unnecessary listing the matter, it's a wastage of time. You spend time
Yes,
granting granting adjournment.
that's true. That's true.
Maximum time is spent in granting the adjournment, then spending time in hearing the matter. So it has to be changed. Something little, of course, adjournment will be there always, but not that kind of.
Item number 20.
20. What is this matter?
This.
Compassionate appointment.
Compassionate appointment, it was.
Plus,
I've said you to
I
find
have
out.
informed him, Lordship, verbally, Lordship.
So what is it?
He said he has some difficulties this morning, Lordship. He wanted to take up next week, Lordship. No one is representing him,
I thought I'll dispose of this matter.
Lordship.
Or you, do you have any apprehension? It's a compassionate appointment.
Lordship,
Why drag for many years?
yes, Lordship.
Anyway, Mr. Moajemi, learned counsel for the petitioner. Mr. Non-appeals for the respondent on call. Non-appeals for the respondent. Not call, huh? Only prayer. Mr. Moajemi, learned counsel for the petitioner. List this matter next week,
Lordship.
after a week.
Item number 21 and 22.
Yes.
The principal counsel is indisposed. Let it come up after 4 weeks.
Huh?
The principal counsel is indisposed.
Which principal counsel?
Mr. N.K. Lukham.
Huh?
Mr. N.K. Lukham.
Eke Buya.
N.K. Lukham.
Where he is? What happened to him?
He's indisposed.
Huh?
He's indisposed.
He is
Indisposed.
indisposed. Why? How?
He's not feeling quite well.
He's not feeling well. He's too old. How old he is?
60s.
60s. Okay. Mr. You are for petitioner. Huh? Appellant. You are happy. MS so learned counsel for the. They heard MS so learned counsel for the appellant. Mr. So learned counsel. Appearing for, you are also in this case. Submits that. The principal counsel. We call it a principal counsel. Principal counsel, Mr. N.K. Lukham, learned counsel for the respondents, is indisposed. Therefore, press for listing the matter after 4 weeks. Is the prayer not being objected to by MS so learned counsel for the appellant? Happily. Not objected to by the learned counsel for the appellant happily. List of prayer is allowed. List after 4 weeks.
Item number 23.
You just delete the opinion.
Lordship, this is a transfer petition, Lordship. I'm
Yeah.
reviewing the sole responsible. This matter might be taken up for hearing, Lordship, next week.
Next week.
Yes, Lordship.
Any difficulty?
You're
From where you are seeking transfer?
from June to Dimapur.
Mokokchung to Dimapur.
Yes, Lordship.
Okay. You are staying in
I'm still
Dimapur
in Dimapur, Your Lordship.
and the respondent,
Respondent is presently he is posted at Longland.
Long Line.
Yes.
So we'll transfer it to Long Line.
No,
Huh?
actually, I'm looking after my alien daughter.
Okay,
He has undergone a heart surgery.
okay. There is more serious. Agree. You are no longer in Mokokchung.
Yes, Lordship.
You are in Long Line.
I'm posted in Longland also. The petition filed.
Anyway, he is seeking next week.
It's no objection.
Heard Mr. So-and-so, learned consent for the. Also heard Mr. Mojamin, learned consent for the respondent. Mr. Mojamin, learned consent for the respondent. Fresh for and granted 2 weeks, 1 week time. List this matter after a week.
Much obliged.
Item number 24.
We'll come back later. We'll just come back after 5 minutes.
My lord,
How long this will take?
30 minutes,
Huh?
30 minutes, lordship.
By 30 minutes. Criminal petition.
Yes. The facts, narration of facts may take 10-15 minutes and some citations, that's all, lordship.
Do you agree? Can you quash it? No issue.
The complainant also, they have already withdrawn the FIR.
And there's no case where
Yes, lordship.
withdraw, it has been allowed to withdraw. FIR has been allowed to withdraw. Is it
No,
permissible
lordship,
under
that
the
they
law
have already submitted,
for withdrawal?
yes. Before the
May not be
magistrates.
permissible. Is it a joint petition?
No, it's not a joint petition, lordship.
A respondent, whatever the respondent.
We have already served notice upon a respondent number 2. I don't think they will appear. In the withdrawal letter also, they have made a passing comment, lordship, that they will not be appearing.
Why they'll not appear?
Lordship, they are saying that
They
they
should
will.
come and support you if you have compromised.
Not exactly compromised, lordship, not between the two of us, but some other civil societies, lordship, they have stepped in and through the intervention, lordship, the FIR has also been.
Just come back after 5 minutes.
Lordship.
Yes.
May I please, my lord? Lordship, I may be allowed to dwell on the facts for a short period of time now. Now, the respondent number 2, my lord. The president wrote a letter to the present petitioner, my lord, way back in 1993, which I have also annexed in my writ petition. At the annexure 2. On the subject application for renting the building.
Where it is? Page.
Annexure 2, lordship, it is at page 23 and the type copy is at page 24.
Yes.
I may be allowed to read from the type copy, Lordship.
Hmm.
So, Lordship, reference Office of the Naka Students Federation, headquarters Kohima, so and so, reference number so and so, date 4 April. To the General Secretary, Naka Club, Kohima, Nagaland. Subject application for renting the building of Naka Club. Sir, on the subject given above, I have the honor to bring following few lines for your sympathetic considerations. That, sir, as you are well aware of the fact that NSF is a student organization having no source of regular income. And as a matter of fact, many a times our programs are hampered due to financial stringency. Therefore, your good office is requested to kindly give us the Naka Club building near Civil Secretariat Kohima on rent basis, so as to enable us to utilize the money which we are paying to others for the benefit of our people. Thank you in anticipation. Yours faithfully, President, Naga Students Federation, Kohima, Nagaland. So, Lordship, passing on this,
What is Koknalim?
it's a sort of salutation in Naga language, my lord.
Koknalim.
Yes, Lord.
Okay.
Now, by the very next annexure, that is page 25, my lord.
Yes.
The Naka Club, that is the petitioner, they set for a meeting and then they decided that
This which date? 4th April, which date?
1983, Lordship.
83.
Yes, Lordship.
Hmm.
Now that is 40 years has already come, Lordship.
Yes.
The
Next page.
Yes, Lordship. After that, the present petitioners organization, they held a meeting and they decided that the building shall be allotted on rent to the respondent number 2. I may be allowed to read the order. Order, the Naka Club Authority hereby allowed a part of its building, former CCF office, to Naka Students Federation with the good consent of mutual understanding on the rental basis with effect from the date of issue of this order. Now it
Yes.
is
83.
Yes, 83.
It was rented.
Yes, it was
Rented out to
7th
them.
of April 1983, my lord.
Hmm.
Now, it is clearly written that former CCF office. That means, Lordship, the Chief Conservator of Forest.
Hmm.
This is the department, the Forest Department was occupying that building. Now, after they vacated the building, the Naka Students Federation, they came and occupied that same building, my lord.
Hmm.
So since then, on a rent amount of 500, Lordship, the respondent number 2 has been continuous occupation of the property, Lordship. Now,
It's a former CCF office.
yes, Lordship.
How you are, what is Naga Club?
Naka Club, Lordship, it has a historic significance, Lordship, to the
Okay.
Naka people because it was.
So this building was given to you? CCF office?
No, Lordship. CCF also, Lordship, was my tenant. The
Okay.
Forest Department was my tenant, Lordship. It was originally given to me by the Kohima village, to the Naka Club, Lordship.
Hmm.
I have also annexed that
Take-
document, Lordship.
It's okay. Hmm.
And Lordship, after they came and occupied the building, except for the first month, my lord,
Hmm.
no proper rent was paid. Sometimes they used to give 50 rupees, sometimes they used to give 100 rupees. But despite that, Lordship, the petitioners organization, the club, kept the respondent number 2 as the tenant because they also understand the difficulties.
So
faced-
they are a student,
Yes, Lordship.
students
exactly.
organization.
Yes, Lordship.
Yes.
Yes.
From when
And
they will get the money
yes,
to
Lordship.
pay the
exactly.
rent. Ah.
Yes, Lordship.
Then
Now-
what happened?
Then the building has now become old, rickety, dilapidated because Lordship, it's a very old building. Now, the club, they decided that the old building shall be brought down, demolished, Lordship,
Ah.
and then a new building shall be erected in its place. Now, it was also verbally communicated, Lordship, to the respondent number 2, that even after the new building is constructed, Lordship, the respondent number 2 shall be allowed to stay as tenant in the newly constructed building. Now, for that, they were supposed to have a meeting, Lordship. But all those verbal communications to have a meeting did not bear any fruit. As such, Lordship, a letter was written, Lordship. Yes, by the petitioner to the respondent number 2, Lordship, on 2 occasions, Lordship. The letters I have annexed annexure 6 and 7. At page 29 and page 30 respectively. The first letter is dated 24 November 2020. Here I have made my intention clear, Lordship, in the letter itself. I may be allowed to read request for meeting. In order to save the court's time, I may be allowed to read the body. Referring to the subject cited above, the working committee in Naka Club would like to have a meeting with the Naka Students Federation concerning the Naka Club building near All Secretariat Complex, Kohima. So a meeting was supposed to be held, was requested to be held concerning their own building, my lord, the petitioner's building, to the Naka Students Federation. Now there was no response, Lordship. Therefore, after almost a year, the following year, on 20 October 2021, another letter was written. Making the intentions clear that we resolve the issue of the Naka Club building. Now, despite that, Lordship, the respondent number 2, they did not come to sit for the meeting, Lordship. Now, Lordship, this is important. In 2018, the petitioner club, they achieved 100 years of existence. Now, during that time, one member who had rented out the premises in 1983, he was still alive. And he is still alive, and he is the advisor of the Naka Club at present, Lordship. Now, and since this is not a private office, Lordship, the officers also, they kept changing, and Lordship, in 2017, communications were made to the Naka Students Federation, Lordship, that in order to commemorate the centenary, Lordship, a monolith was desired to be erected by the petitioner club at the Naka Club site, Lordship. However, the respondent number 2, they agitated. And at that time, Lordship, they organized, mobilized some students, and those students, Lordship, oblivious of the existence of the original, the true actual story, Lordship, of the historical facts. They came, they participated in the agitation, and at that time, Lordship, some situation developed, and fortunately, some communities, Lordship, came forward, some tribe came forward, offering the Naka Club to erect the monolith in their area. But finally, it was decided that the monolith shall be erected at Chotsama village, Lordship, because one native of Chotsama village is considered to be the first martyr of the Naka political cause. So it was decided accordingly, and the monolith was erected at Chotsama village. On I have annexed, Lordship, a photograph at page 4, annexure 4, page 27, Lordship. The picture is taken on 29/11/2018. That is the day the monolith was erected.
It's okay.
Yes, Lordship.
Where should
Now,
go?
yes, Lordship. Now,
If is there anything?
I am also the pata holder, Lordship.
It's okay. Is there anything
No, Lordship.
that it will proceed?
No,
You have stopped,
Lordship.
no investigation, nothing.
No, since they have withdrawn, Lordship, withdrawal letter is at page
I have annexed my additional affidavit, Lordship.
Page 13. Type copies.
Page 13, additional affidavit, my lord. Page 13. The original copy is at page 12, type copy is at page 13.
Page 13.
Yes, Lordship.
Additional.
Additional affidavit.
They have also stated that material would be sent outside the game.
Any case diary?
No.
Nothing. If there's nothing, what's the question of
Lordship.
washing?
At the stage of motion also, the opinion expressed by the court was that this is a civil dispute, Lordship. And why, even if there is a dispute, assuming there is a dispute between the tenant and the landlord, because I'm the landlord and the respondent number 2 is the tenant, then it should be settled in a civil court. The filing of the FIR is misconceived, Lordship.
Where's the FIR?
FIR in the same additional affidavit, Lordship, at
Page 9.
page 9, Lordship.
Type copy, page 10.
That copy is at page 10. Construction permit also I have obtained from the municipal council, Lordship. I have annexed the same. Vacation notice I have served on 2 occasions, Lordship, giving them 45 days on each occasion.
What is the vacation notification notice?
The first notice I have annexed at annexure 10, page 35. It was served on.
What I'm saying is, if nothing is there,
Yes, my lord.
not as a withdrawal, he can. This has been registered.
Yes, Lordship, I believe so. The GR case has already been registered.
No, police case, whether the FIR has been registered or not.
FIR, Lordship,
Registered, not PSQs. Yes, yes,
there was page 9.
yes,
GR
registered.
has been registered, Lordship, yes.
Okay, we'll allow.
No. If I may, Lordship, we are allowed to place some citations, Lordship.
Where it is, which you have annexed.
No, I have not annexed, but I have submitted the police, Lordship.
No, you have annexed this writ petition also. And this petition also.
Yes, Lordship, I have annexed. But I want to submit other citations.
Which one?
Short citation, Lordship. 2017 4 GLD 356.
2004.
2017 4 GLD, Lordship, 356. Paragraph 16 and 24. These are very short paragraphs, Lordship.
356. Huh?
356, 356, Lordship.
Hmm.
Paragraph 16 is at page 359, my lord. Lordship, I may be allowed to read 16. not the entire, but the first portion of this, paragraph 16. Again, in the case of Indian Oil Corporation versus NEBC 2006, 6 SCC 736, the Honorable Supreme Court noted that it is necessary to take notice of a growing tendency in business circles to convert purely civil disputes into criminal cases. This is obviously on the account of a prevalent impression that civil law remedies are time-consuming and do not adequately protect the interests of lenders, creditors. Such a tendency is seen in several family disputes, also leading to irretrievable breakdown of marriages, families. There is also an impression that if a person could somehow be entangled in a criminal prosecution, there is a likelihood of imminent settlement. Any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged. Paragraph 24 says that criminal law is not a shortcut, Lordship, for civil remedies. Lordship, I may also be allowed to place 2007-12 SCC.
Why burden with all this? It's okay.
Lordship.
I have Mr. Centenary Council for the petitioner. Also had Mr. B.G. Mogi, public prosecutor for the state. For respondent number 1. Lord appears for the respondent number 2. Despite service of notice. Which has been effected through Dusty.
Yes, my lord.
Mr. Next, by filing this petition under section 482 of CRPC 1972. About the petitioner has prayed for washing of FIR dated 27/5/2023. And consequential criminal proceedings. In connection with which has been registered. Where is this?
It has been registered at North Police Station, Kohima.
Registered is Kohima North PS case number 0021 of 2023. Under section 457, 428, 120B and 34 IPC. Next bill. The case in nutshell is that an FIR was lodged by respondent number 2.
Yes, Lordship, respondent number 2.
Lodged by the respondent number 2. That is the president of Sri Kegwayun Tep. Page 2. The president of Naga Students Federation. Alleging that their office premise and the building has been damaged on the early hours of 27/5/2022 by unknown miscreants. Accordingly, the case was registered as Kohima North PS case number 0021/2023. under section 457, 427, 120B and 34 IPC. It is the contention of the petitioner that the land on which the Naga Student Federation office is presently established, along with some other adjacent buildings, where others of public offices, public printing press are established or given to the petitioner by Kohima village listed. Accordingly, the authority has issued patta measuring an area of 9257 square feet situated at All Secretariat Complex, Kohima. On 14/4/2021 in favor of the petition. Next step. The petitioner being the owner of the building wrote to NF Naga Students Federation on 24/11/2020 and 20/10/21 for a meeting regarding the Naga Club building. However, the Naga Students Federation never turned up, nor did they pay the rent. The building was the part of the building was allotted to the Naga Student Federation way back in 1983.
Yes, Lordship.
On being approached by the then Naga Student Federation on rental basis. Mr. Thereafter, the petitioner, after waiting for 6 to 7 years, served an eviction notice to the respondent number 2, who had later dated 12/7/2022 and 6/3/2023. Mr. And 22. As the petitioner has decided to demolish the building for new construction.
Yes, Lordship. We have also obtained construction permit from the Kohima Municipal Council.
For
Which
construction of new building.
Page 33.
Mr. The petitioner has obtained construction permission from the competent authority for its new construction new building on the land situation on the land where the present Naga Club building is standing off, for which demolition has to be demolition has to be done. Next paragraph. A petitioner contends that it is not only the Nagas to the respondent number 2, but all the other occupants of the Naga Club building where they have been asked to vacate so as to pave way for construction, demolition and construction of new building. Mr. For the purpose of such construction, the empty houses and rooms were demolished as the place is situated in the middle of the heart of the town, and heavy machinery public vehicle is required to dispose of the debris. So it's decided that in order to avoid public inconvenience, the same was removed in the early hours of 27/5/2023. Mr. The petitioner engaged some youths to dispose of the debris of the demolished building in the early hours of on 27/5/2023. On such demolition, on such removal, on such act of removal of the debris in the early hours of 27/5/2023, the respondent number 2 filed the above referred FIR without there being any offense. However, it is the respondent number 2 who they have not paid the rent.
No, except for the first month, that is
Who
April
never
1983.
who have never
Except for first month.
paid the rent to the petitioner, except for the month of
April 1983.
April 1983. Mr. According to petitioner, when the removal has been done, a removal of the debris has been done so as to avoid public inconvenience on the early hours of 27/5/2023. The question of vandalizing public property or criminal trespass by unknown miscreant alleged by the Respondent number 2 does not arise. Mr. That's this present petition for quashing of the FIR dated 27/5/2023. Next back. Mr. Santiago Leonard counsel for the petitioner. So Mr. The petitioner being the rightful owner of the building of Nagar Club building has decided to demolish and construct a new building as the buildings that became dilapidated by lapse of time. The petitioner has also obtained request permission from the competent authority for such construction. Next, he further submits that
I am the pata holder.
Huh?
I am also the pata holder.
That we have seen. The respondent number 2, despite receipt of eviction notice, as you'll not notice despite receipt of notices for eviction, has filed the false FIR of vandalizing public property or criminal trespass, alleging vandalizing public property or criminal trespass by unknown miscreants. Mr. Therefore, press votes quashing the FIR. That is 27/5/2022. It has been registered as Kohima, not Kohima, Kohima not PS case number 0021 of 2022, section 457, 420, 120B and 34 IPC. Before that, he further submits that during the before praying for quashing, just before that. In the meantime, the parties have entered into a settlement, and on the intervention of
The Angami Public Organization, my lord.
some organization and resolve the misunderstanding between the petitioner and the respondent number 2. Then you said that quashing and so on. Mr. Bijay Leonard PP submits that he has no objection for quashing of the FIR, as the matter has been amicably settled on between the informant and the petitioner on the intervention of the social organization. Mr. Happy. Next bill. What you are, do we need to rely on this thing? Huh?
It's okay, lordship, it's all right.
In the case of Bhajanlal versus State of No, in the case of the state of Haryana versus Bhajanlal, 1992, supply within bracket 1, bracket close, SCC 335. Is it? Is it the correct citation?
The citation that I have submitted is 2017.
No, it's okay.
4033.
No, I'm relying on Bhajanlal.
Lordship.
The Honorable Supreme Court laid down categories of cases. You just read that the Honorable Supreme Court has laid down category of cases by way of illustration wherein the power under section 482 CRPC could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Those circumstances are as follows. This one, page 360. 1, 2, 3, 4, 5, 6, 7. Having considered the learned counsel, submission of learned counsel to the parties and perusal of the FIR as well as materials available on record. This court is of the view that the allegation made in the FIR do not disclose the commission of any offense and make out the case against the petitioner. As the demolition and removal of the debris by the engaged persons of the petitioner cannot be said to be a vandalizing of the public property, or for that matter, much less the criminal trespass. Moreover, after the filing of the FIR, the petitioner and the respondent has resolved the issue as according to them, as the same is out of sheer misunderstanding between the parties.
They have withdrawn the FIR.
Huh?
They have withdrawn the FIR. Respondent and withdrawn the FIR.
It is also noticed that the respondent, the informant, respondent number 2. Informant oblique respondent number 2 has sought for withdrawal of the FIR by himself. Though the permission to withdraw the FIR is permissible under the law, is a different issue altogether. Next, in view of the, that's all. In view of the above, this court is of the view that the petition be allowed, the present petition be allowed, washing the FIR dated 27/5/2023 by invoking the inherent power of this court under section 482 CRPC about 1973. Accordingly, the FIR dated 27/5/2023 being Kohima North PS case number so and so, under section so and so is hereby quashed. Not in the result, petition is allowed and disposed.
Deeply obliged.
Well, got shortcut where unnecessary burden the orders. You pick this one. Sure.
Kak, itu bila je na?